Hello guys and welcome to LawPutra's YouTube channel. Today we will discuss the most important, basic and quite good old act, that is Indian Contract Act 1872. And today we will talk about the rights and duties of PAWNOR and PAWNEE. I am Jagannath Kulkarni and I welcome you all to this discussion today. Before we talk about the PAWNOR and PAWNEE, let us discuss as to from what the concepts has arisen. So we will discuss about the bailment, bailer and bailee, which is given definitions in section 148. It says bailment, bailer and bailee, how they are defined. Bailment is delivery of goods by one person to another person for some purpose upon a contract that they shall either, when the purpose is accomplished, be returned or otherwise disposed of. The goods which have been delivered earlier, either those will be returned or they will be disposed of when the purpose is accomplished. What is the purpose? It is upon some contract, whatever contract may be entered between these two persons, according to directions of the person delivering them. So who initiates? Initiates the person who delivers the goods, and he is called as the bailer. And bailee, obviously the person to whom the goods are delivered. So this is very simple arrangement of bailment under Indian Contract Act. Now from this bailment, what we have derived is the pledge, and the concept have come as pledger and pledgee. Similarly, PAWNOR and PAWNEE. So popularly they are called as PAWNOR and PAWNEE, but basically they are pledger and plenee. So obviously, pledge, it is a bailment of goods when it is used as a security for either payment of debt or for performance of certain promise. So this is a peculiar design contract, that is the pledge, and obviously the bailer becomes the pledger or PAWNOR in our discussion, and obviously the bailee will be pledgee or PAWNEE. Now, having considered this, let us see what are the other provisions. When we talk about the PAWNOR and PAWNEE, the PAWNEE's right will be more important because he is in the receiving position. So right of retainer, PAWNEE's right of retainer is given in section 173. It says PAWNEE may retain the goods pledged not only for payment of debt or performance of promise, but for interest of debt and all necessary expenses incurred by him, because he is holding the goods, in respect of possession or for preservation of the goods which have been pledged earlier. So this is the PAWNEE's right. He got the exclusive right over those goods. Now, when PAWNEE cannot retain for debt or promise, other than that for which goods pledged, presumption in case of subsequent advances. So, whatever has been originally stipulated has to remain. This is given in section 174. PAWNEE shall not, in absence of contract to that effect, retain those pledged goods for any date or promise which is other than the date or promise for which they have been pledged. So original date or promise is important, but such contract, in absence of anything to contrary, shall be presumed in regard to subsequent advances made by PAWNEE. So remember this. Now let us discuss about the PAWNEE's right as to extraordinary expenses incurred. Obviously, section 175 talks about that. So PAWNEE will always be entitled to receive from PAWNOR, the original deliverer of goods, extraordinary expenses incurred by him for preservation of those pledged goods. This can also happen. Whatever goods have been pledged has to be stored and preserved by the PAWNEE, and so he is entitled to the expenses. Now PAWNEE's right where PAWNOR makes default, this is given under section 176. Now it says if PAWNOR makes default in payment of debt or performance of promise at stipulated type of promise in respect of which the goods were pledged, then the PAWNEE again will have the right What rights he has got? He may bring suit against pawner upon date or promise, or he may retain the goods pledged as collateral security, or he may sell the goods thing pledged or goods pledged on giving the pawner reasonable notice of sale. So he can bring the suit, he can retain the goods, or he can even sell the goods. Who? Pawnee. If sale proceeds are less than amount due in respect of date or promise, the pawner is still liable to pay the balance. Obviously, the pawnee has got right over the whole amount. If sale proceeds are more than amount due, greater than, then pawnee shall pay over surplus to pawner, obviously, to set off the transaction. So these are the pawnee's rights. Then suppose the pawner is defaulting, then what is his right to redeem? It is given under section 177. So if time is stipulated for payment of date or performance of promise for which the original pledge is made, and the pawner makes default in payment of date or performance of promise at stipulated time, obviously as expected, then he may redeem the goods pledged at any subsequent time before actual sale, but he must pay in addition any expenses which has arisen from his default. So defaulting pawner's right to redeem, but with the condition of payment of expenses, additional expenses. Now, pledge by mercantile agent. This is also thought of in the Act. It is given under section 178. Now, mercantile agent is as per the Indian Sale of Goods Act, and where mercantile agent with consent of owner in possession of goods or documents of title to goods, any pledge made by him when acting in ordinary course of business of his mercantile agents, he shall be as valid as if he were expressly authorized by owner of goods to make it, but provided pawnee acts in good faith to whom the goods have been pledged, and he has not at time of pledge notice that pawner has no authority to pledge. Now, also section 178 talks about the voidable contract. What happens? In case of pledge by person in possession under voidable contract, what can be done? If it is voidable under section 19 or section 19A, but it has not been rescinded at time of pledge, then pawnee acquires a good title to goods. He acts in good faith and without notice of pawner's defect of title. So the benefit of doubt is given here also. Section 179 talks about pledge where pawner has a limited interest, only limited interest, not a full interest. So where a person pledges goods in which he himself has only a limited interest, then pledge is valid to extent of that interest. Obviously, this is very expected. Now, let us discuss one case, State Bank of Saurashtra versus Chittaranjan Ranganath Raja and another. What happened in this case? So this bank acted as pawnee because Chittaranjan was the borrower, so becomes pawner, and he pledged 5,000 tins of peanut oil as security for loan of 75,000. Unfortunately, pledged goods were lost while in bank's possession, and bank filed a case against pawner to seek reimbursement of loan amount. Court dismissed the petition since bank as pawnee who has the borrower's goods, making it unable to recover its payment. So this is the one case which has been discussed. Let us summarize. Pledger and pledgee, pawner and pawnee. Pledger transfers or bills the goods to pledgee, that is pawnee, as security against the amount he takes from pawnee. Pawner has duty to pay the amount back to pawnee. Pawnee has duty to return the goods after pawner pays the amount. And pawnee should not make unauthorized use of the goods bailed to him. If he does, he will be liable to pay compensation to pawner. So this is also important. Abuse of goods not allowed. Pawnee has right to sell the goods after giving prior notice to pawner if that pawner fails to pay the amount back. So, thank you very much, and today we discussed about the Indian Contract Act 1872 and the important topic was rights and duties of PAWNOR and PAWNEE. Thank you. Thank you very much.